Uh, Good morning, members of the jury. All of you now sworn in or affirmed to try this case. I know that you've had some technical instruction before you were selected to try the case, and you're aware, I know, of the chat function that gives you two things. First of all, a direct and confidential line to me. So if you have any problems, any questions, anything at all, then you can send me a direct message and I can deal with it directly. In the more familiar world, you would send a written note. That's the alternative. The other thing that it does is to give you access to documentary and other material, and I know you're familiar with that through the instruction that you've been given. Amongst the material you've got, just nod if I'm right, I think I am, is a document that sets out your duties and obligations as jurors. Have you all seen that? You're all nodding your heads. Good, excellent. It's very important that you read it, not during the time the court is sitting, but at your leisure when the court is not. I need to emphasize briefly and quickly one or two important aspects of it. First, the importance of the instructions in themselves. They really do matter. They ensure, amongst other parts of our process, that the case is tried fairly, and you have your part to play in that, obviously. The fact that they matter so much is demonstrated by what can happen to jurors if they don't obey the rules. I'm absolutely certain that you will, and please don't think that I'm suggesting for a moment otherwise, because I'm not. But just very occasionally, jurors don't, I'm afraid, obey the rules. And there have been one or two cases, very unusual, but they have happened, where jurors have been punished for not obeying the rules. I'm saying that not in any way at all to threaten you, but to emphasize to you the fundamental importance of complying with the rules. Secondly, and briefly, let me stress, please, the importance of reaching your verdicts on the evidence that you hear in court. You apply your knowledge of the world and your good common sense to that evidence, but it's the evidence that will determine your verdicts and not anything you discover by talking to anybody else or by doing any sort of research. The document that I'm talking about makes that entirely clear, but you'll forgive me, I hope, for emphasizing the importance of it. It's the evidence in court that will determine your verdicts, and it's the verdicts of you, the 12 of you, and nobody else, and so it's very important you don't discuss it, as I say, with anybody else. I want quickly to add a couple of other things in relation to the nature of this trial. It's not the usual trial that in different times we've been accustomed to, because of course we are, all of us, in different places rather than together in the same court, same room. But the first and most important thing to stress is that even though we are conducting this trial in this remote way, it's still a real trial. The defendant is a real person, the witnesses are real people, the events, real events. And the trial will be conducted just as if we were all in the same place at the same time. The same rules of procedure and evidence will apply. It's no less serious and in all those ways no different from the trial that we are familiar with in the courtroom setting. One of the aspects of this means of conducting court proceedings is that whereas in the real world people quite often talk over each other, and it's quite easy by body language and other ways to overcome that. But in this environment, if we do talk over each other, then we just won't hear what anybody else is saying. I'm saying that as much to myself as to anybody else. I'm saying it to counsel, and I'm saying it to you because when you do retire to consider your verdict in this case, it's very important that you don't talk over each other and that you conduct your affairs then and at all times in a courteous and well-mannered way. And that good manners are important always in life, but they're particularly important in this environment, because if we are not well-mannered and courteous, then we simply won't hear what we're saying, and the proceedings will become, to that extent, chaotic. People say, and maybe they're right, that looking at screens, as we will be doing during this trial, is more tiring than listening to a case in the familiar environment. And there's no doubt something in that. So we're all going to have to work hard, all of us, to keep up our concentration. I will ensure that you get breaks during the course of the hearing so that you can, as it were, recover yourselves. We can all do that. But will you forgive me if, as the trial unfolds, and I notice that any one of you, and I will have you very much in my sight as the trial goes on, if any one of you appears to be drifting off, will you forgive me if I say something gently and kindly designed to bring you back into the room? I'm sure it won't be necessary, but I've asked your permission to do it now and make my apology for doing it if I have to, should it arise. I want to say something also about the assessment of witnesses. There's an interesting discussion to be had as to whether it's possible for people like you, jurors in trials, and indeed judges in judge-alone trials, to make a good and accurate assessment of the truthfulness or reliability of a witness, where that witness is not physically, directly in the presence of the jury or the judge. There's a great deal of research that actually suggests that that's not the problem that people sometimes think that it is. And indeed, that's acknowledged in our proceedings because it already happens a great deal that juries in the conventional setting frequently hear from witnesses giving evidence over a remote link, a video link, particularly in cases where witnesses are vulnerable, where the allegations are, for example, of sexual offences. That's been done for years and has been done without problems. The presentation of the witness is often said by some to be a critical way of assessing evidence. As I say, that the research suggests otherwise. And in fact, reality tells all of us that people's demeanour can be the result of all sorts of things, nothing to do with truthfulness or reliability, just plain nervousness. Sometimes cultural factors. There are people who have been brought up in some cultures who regard it as disrespectful to look others directly in the eye, whereas in other cultures it's regarded as a sign of unreliability or untruthfulness. It really depends, in that example and others too, on all sorts of factors which have nothing to do with truthfulness or reliability at all. And the fact is that we have within our justice system in this country and in other systems internationally, judges are called upon to make assessments of truthfulness and reliability who are blind. If anybody is prepared to have a discussion with judges or magistrates who are visually impaired on the topic of whether they are able to make assessments of witnesses, well, do feel free to do so. I suspect they would all tell you in strong terms that they're as good at it as anybody. It just simply does not depend on what you can or can't see. But if you disagree with that, and I know there are some who do, can I reassure you that you will actually, as the trial unfolds, get a good view of the witnesses. Nowadays, certainly in my court, and other judges take the same course, I know, you would only see the head and shoulders of a witness because witnesses generally are allowed to sit in court rather than stand, as they once did. And if you, as a jury, were assessing that witness, you would do so across the width of what could be quite a large courtroom. Well, here, you will actually see in sharp focus, in a box on your screen, the head and shoulders of all of the witnesses. So if demeanor matters, as I myself think it doesn't, but if you take a different view, that's fine, you will have every opportunity to make as good an assessment of the demeanor of a witness in this environment as you would in the court environment. So I've taken a little time to say all of that, but it's quite an important topic, and I wanted to do my best to reassure you before we start that you will be able to perform your important function in this environment as much as you would in the more conventional one. Almost done. You mustn't film or record these proceedings, screenshots, whatever it may be. There are strict laws about doing that, and it's very important that you don't. It's important that as you sit listening to the evidence, that any devices that you have are at least switched off. Better that you don't have any devices other than the one you're using to access the case, actually not in the room at all. That you mustn't be distracted by any devices during the course of the hearing. And finally, I know that you've been told this, that you must be in a room, as all of you I'm sure are now, on your own. There mustn't be anybody with you observing you as you perform your functions as jurors. You understand why the risk of there being, as it were, a 13th, 14th, 15th silent juror in the case is one that we must plainly avoid. I'm sorry for the lecture, but these are important aspects of the process that I do need to say something to you about before we start. You're relieved to know that I've said now all that I proposed to say. And now Mr. Trafford, who you can see labelled as prosecution, is now going to open the case to you to tell you what the prosecution says all about.